could we stop at your first point? Because what you're arguing is that the statute here impliedly reversed FISA's application, correct?
So no, Justice Sotomayor, I don't think that's right. I'm happy to, I think we reached the level of clarity necessary for that, but that's not how this court talks.
Well, let's go to that.
Okay.
I mean, we do know that in Kurtz, there was no statute. It was just how to read this statute, correct?
That statute in conjunction with background principles.
Background principles, but not another statute. The idea of irreconcilable conflict was present in Kurtz itself. And the court explained that if Congress enacts a cause of action against a governmental agency, and there is no way to bring that claim, those were Kurtz's words, against any government agency, then the cause of action itself must abrogate sovereign immunity. But that's not the case here. In fact, you've brought a claim that still survives against CIMEX. And as I'm reading the record, there's been so much investment in Cuba, even before the current president. CIMEX itself operates Western unions on confiscated property. There's over 100 companies since 2001 that have exported products to Cuba. There's ongoing agricultural and other exports. So this isn't a dead letter if we impose sovereign immunity principles here. That's very different than Kurtz, isn't it?
Justice Sotomayor, let me say a couple things about that. First is, we don't know if it's a dead letter. Nobody has actually successfully made a claim through yet. Our claim, after 7 years with one of the largest and most diverse claim, has not yet made it through. But more importantly, I don't think Kurtz says you need to have a dead letter. What Kurtz says is, if Congress defines a claim, specifically applies it against a government entity, and applying immunity in that circumstance would negate claims Congress wanted, then we think that's a pretty good sign that that statute itself abrogates immunity.
You're going in a circle, Counsel. You're trying to read an intent into Congress by saying they wanted a bigger claim than the one I could have. But if a claim is still possible, what that means is that the two statutes, FISA and Title III, can be read harmoniously, which is our charge, not to implicate repeal.
Justice Sotomayor, so let me address the Kurtz point, and I do want to go back to why this is not an implied repeal. On Kurtz, again, I think it is unequivocal that this would effectively negate many, maybe most, maybe all of the claims that Congress authorized. Kurtz did not rest on a notion that 100% of the claims could never come through.
Well, I think it's